Good morning. Welcome to the latest in the Owen Mitchell series of Brexit briefings. My name is Bruce Macmillan. I'm the General Counsel of Owen Mitchell, and I have been working on Brexit related issues since they first became part of the Conservative Party manifesto several years back. I also co-lead the Owen Mitchell Group's own response to Brexit, making sure that we're as ready as we can be and continue to be prepared and adapting to evolving circumstances. It's great that you're with us today in this series of activities, and we have over 300 people signed up for today's session, which has had some effects on the format, which I will mention in a second or two. We intend today to take you through some key issues and areas which have come to light as a result of the deal that was negotiated at the end of last year and through the changes that have come to light in the last couple of weeks. In today's format, what I intend to do is to make a couple of introductory comments, then to introduce our speakers who will be working on different topics for you over the course of the next hour. We'll then ask each of the speakers in turn to look at the biggest individual change and or area of uncertainty in their area of practice which may affect you, before going on to look at some more specific questions from each of the areas that are represented today. We've chosen the areas and the panelists based upon pre-submitted questions that have come into us and which relate to a number of topics. We've had so many pre-selected questions that what we've actually had to do is to group them and synthesize them into summary questions which give you the specific context. And we'll seek to answer those questions over the next 35-40 minutes, while also offering the opportunity for you to raise questions through the chat function on this call. And we will try and answer some of those questions in the time that's available. But please, any questions that you do submit, we will come back to you on following the session, including ones which are relevant to you, which relate to the topic, but which are not addressed by the speakers on the call today. I'm very pleased to say that all of our speakers today have volunteered to do a free 15-minute follow-up on any of their topics with any of the people on the call today who wish to discuss a topic further that's been raised or a new issue. Obviously, beyond that, we then need to have a wider discussion with you to make sure that we could help you more. The only exclusion to that, I'm sorry, is that we do know that there are a few people from other law firms listening to us today. So while we're delighted that you're on, I'm very happy to listen and engage with you on this. The 15-minute free service isn't available to you. The topics that we're covering today relate to employment, to immigration, to tax, to the supply of goods and services, which we'll touch on briefly, because there's a lot on the supply of services that's unclear at the moment, and we'll be preparing a follow-up briefing note for you probably by the start of February, but that depends on having sufficient clarity on laws and regulations to be able to provide a meaningful commentary. On consumer law, on the reinforcement of judgments internationally, and also on the impact on Northern Ireland. As many of you will be aware, Northern Ireland, in many respects in relation to goods and goods supply, is now treated still as being part of the European Union and not part of the United Kingdom, and this has created a number of issues. In this context, I'm pleased to say that one of our relationship law firms through the Avrio network, Caldwell and Robinson, have got a couple of people from their team listening in on the call today, and they will be able to chip in and add comments as appropriate if it's helpful to do so. And we're working with them jointly to help look at both sides of issues emerging on the Irish border. As a couple of high-level points that are worth bearing in mind as we go into this conversation, the first one is, while this is all feeling very different and a lot of the things that we're used to have now been taken away, it is essentially what this government intended with its 80-seat majority to deliver. So directionally, what we've got now is what we're likely to have in the future. And it is important to look at the mood music of what the government is doing and saying. For example, Rishi Sunak's announcements yesterday about City 2.0, because this is the direction that they want to travel in. And it is intentional. The things that they have done very clearly, they have had the knowledge, they have had the information, they have chosen to do these things. It is not an accident. The second thing that ties into that is that one of the core focal points for them is increasing the power of the English executive. With an 80-seat majority The focus of the government in a lot of their actions through the negotiations and also more generally within English law is to give the executive more power to act as an executive with less control, both temporal in terms of length of time before things can be changed again, like the fishing deal, and also in terms of scrutiny and supervision and other approval, which is why they've pulled away from the European Union. It's why they've pulled away from the European Court of Justice. It's why they've pulled away from a lot of other things such as the Lugano Convention, which I'll come back to. And it's also why they've pulled power away when taking things back from Brussels to the centre rather than giving it to the devolved regions. Additionally, if you look at the direction of travel on judicial review, on the role of the court system in changing UK retained law, and in the way that the House of Lords is currently being changed with increased numbers of appointed peers within it, you will see a direction of travel which is all towards giving the executive the ability to do more with less control, less prior warning, shorter implementation periods, and with less overall consultation. Why does that matter? Well, it means that all of us need to be even more on top of our game in terms of horizon scanning, planning, anticipating, because when things come through, they'll come through very quickly, and they may not come through with much forewarning or detailed preparation. And that's one of the key reasons why we're running these sessions today and over the coming months and the previous months, and why we've built our Brexit Hub online, is to try to help to support you in horizon scanning, identifying where things may change or are likely to stay the way that they are, so that you can plan ahead as much as possible and navigate through these very difficult times that we're going through. And if any of you want to come illustrations of this, which are both interesting and to some extent amusing, but not entirely amusing, just look up Percy Pigg and Marks and Spencer's and Northern Ireland online, or look up the issues that are currently affecting musicians planning to travel for concerts and other purposes across Europe, which have all been in the news in the last couple of days. And not only do these two well-reported cases give you a good microcosm of the issues that we are now working with compared to what we had before, but they also make another important point, which is be careful what you believe and what you read. There's an awful lot of hype and spun content going out from both the UK government, the devolved government and Europe at the moment. And in particular, if you're used to only reading one or two newspapers, please be very careful about that, because they all have very spun views. So the important piece about this is to take a rounded view, to compare data sources and information sources, and to use independent, non-biased advice and sources to try and form a balanced view for you and your business. So turning to the team we have on the call today, I would like to now ask each of our speakers to introduce themselves briefly, and I'll start in the order that people are displayed on your screens now with Sarah Cardew, please.
Hello everybody, thank you very much Bruce for that introduction. I'm Sarah Cardew. I am head of the corporate tax group at Owen Mitchell, with a particular focus on VAT and all things Brexit. And thank you, Bruce, for pointing out that Percy Pigg's article. I'd clocked the musicians one, but not the Percy Pigg's one, and that's a fantastic illustration of what I'll be talking about a little bit later. So now I'd like to hand over to Sibylla, please.
Thank you very much, Sarah. My name is Sibylla Steiner. I'm a partner in the employment team of Owen Mitchell. I'm on the board of the Employment Lawyers Association Brexit group, and I am going to talk about people and workforce matters today. Thank you. I'll hand over to Craig.
Good morning, everyone. My name is Craig Weston. I'm a senior associate in our regulatory team at Owen Mitchell. Today, I'll be giving a bit of an overview as to the implications of the trade deal on the financial services sector, both from a financial services supplier perspective, but also from a receiver of services perspective. I will hand over, when I see the next slide, to the next person, who I think is Kunal.
Morning all. I'm Kunal Gadri. I'm a restructuring insolvency partner at Owen Mitchell, and I focus primarily on both non-contentious and contentious work, focusing on cross-border insolvency and restructuring. And I'm going to be talking about the impact on insolvency proceedings. And I'll now hand over to Joanne.
Thanks, Kunal. Hi, I'm Joanne Bone, and I'm a data protection partner here at Owen Mitchell. The big issue that we've seen in relation to Brexit has been relating to export of personal data, so that's one of the main things that I'm going to be talking about today. I'm going to now hand over to Georgie.
Thanks, Joanne. Good morning, everybody. I'm an IP specialist. I head up our IP and media team in London. I'm going to be talking about some of the changes in relation to your IP rights, particularly around trademarks and designs, which are the principal changes you need to be thinking about right now. I'm going to pass back to Bruce.
Thank you. And before we go into asking each of the panelists today to pick up in more detail on some of the key things that you need to focus on, the big changes and the reasons for those big changes and the big areas of uncertainty, I just want to pick up briefly on the enforcement of judgments point. So Cheryl Palmer-Hughes, who is our partner who is on the Law Society's Lugano Convention Working Group, has given me a bit of an update. She's unable to attend this morning, but we'll be happy to deal with any further questions offline if they're forwarded through to us through chat or email. The key point about the Lugano Convention is it's the effective mechanism through which over recent years it's been possible to enforce judgments, collect debts and so on across the European Union and the EEA. The UK chose to leave the Lugano Convention and then changed its mind in April last year. Having left, it's had to reapply, and we will not know until April whether the European Union, as the last remaining signatory on that, who has to make a decision, will agree to us rejoining. And obviously the possibility is that what the UK government does in the meantime on other things may affect that. In the meantime, broadly speaking, anything which was commenced as a process or a collection before the 31st of December will largely continue as a broad overview under the rules that existed prior to 31/12, but anything new that you commence in way of litigation or enforcement will be under a mixture of the Hague Convention and the national rules of the country where the other party is, which clearly varies a lot country by country and is something which obviously is rather different to what we're used to. So if you need to commence litigation or enforcement before the position on Lugano is clear, or if it turns out that we're not allowed re-entry, then I'd encourage a careful prior analysis of that with relevant experts before you embark on that course of action or try to do so, because it will be quite different to what you've had before. I'm now going to turn back, and sorry, I should also say you can find further information about this and links on the Brexit Hub, as you can see on the screen at the moment, with the Brexit Hub address at the top, which is also a method through which you can connect with any of the people speaking today or any of our other specialists, and the resources that relate to events we've held before, including recordings such as the one of today, and recordings and dates for future events that we are running on an ongoing basis, with a particularly packed agenda, which I'll come back to at the end of the call in the period from now until March. So now if we could go back up 2 slides, please. And I'm going to ask each of our contributors in turn to briefly outline the key areas of concern in terms of major change compared to what we're used to, and or major uncertainty. And having gone through those things, we'll then start to ask the specific questions that have been submitted by pre-submitted by people on the audience today. So Sarah, could I turn to you please and ask you to identify the biggest areas of change and or uncertainty that our audience today need to reflect on before handing on to Sibila, as we did previously.
Thank you very much, Bruce. So, as we all know, the EU UK agreement was produced with great fanfare at the beginning of the year. And the big news from a tax point of view is that it provides for 0 tariffs and quotas. So this avoids the introduction of customs duties and export duties and taxes and charges on goods moving between the EU and the UK. So that's great news. However, and I'm going to highlight this right up front. Bruce talked about the Percy Pigs article in the newspaper. This 0 tariff only applies to goods that are produced in the EU or UK, as long as they comply with the new rules of origin. And I'm going to come back to that because I know a specific question has been asked it. But asked about it, but basically, if your goods don't follow the appropriate rules of origin, then they might not benefit from those beneficial zero rate tariffs. And Bruce gave the example of Percy Pigs, M&S Sweets, and I understand from reading the article that what happens is they're shipped from the UK to Germany. They have a little bit of a manufacturing process there, and then they get sent back and they are supplied to Ireland. And we're going to come on to the issues around Ireland later as well, but because Ireland is treated differently because it's not in the EU, this means that those Percy Pigs are now not complying with the appropriate rules of origin, and there may be a block on supplying them to Ireland, or they may increase in costs. So that is a practical illustration of the kind of problems that we're dealing with. The goods moving between the UK and the EU are subject to a whole raft of new customs checks and procedures, as you would anticipate. So the main thing to do is to make sure that your business is set up in an appropriate way. And I would go back to the original points I made in my last Brexit webinar, which is still very valid here, but UK businesses out there need to consider right now how they are clearing and paying import VAT and duty on goods, and that's both for goods entering the UK and going from the UK to the EEC. You may also need to update your delivery terms, and my commercial colleagues can help you with that here. But importantly, and this is something which is already catching people out, you may need to register for VAT in other EU countries in order to clear the goods and pay import VAT and duty over there. And of course, because of the pandemic and also a host of other reasons, people have left this too late, which can be very challenging and can lead to people refusing to do business with you. Remember also that HM Revenue and Customs can only advise your business on UK VAT. They can't advise you on whether your business is liable to be registered for VAT in any other country and on their registration requirements. So you may need to take further advice from law firms around the EU, which is why we are well placed to help you with our network of law firms around the EU and the Avalo network, which Bruce referred to. So they are the main issues for me from a tax point of view. I am going to come back to a question a little later on about the rules of origin and particular difficulties. But now may I pass over to Sibylla Steiner, please.
Thank you very much, Sarah. From the people and workforce point of view, the main obvious issue is that there is no longer freedom of movement within the EU. That means that as a business, you have to jump over a number of hurdles if you want to employ EU nationals in this country. And also when it comes to business visits from the UK to EU countries or the other way round, it's no longer simply a matter of jumping on a flight or getting in the car and driving over, but you will have to think about what activities it is that you and or your employees want to perform in EU countries, or if you have business partners that want to perform services in the UK, whether those services are what's called permitted activities, and if they are not, how you can get people either over here or go from the UK to the EU with a visa. As far as going from the UK to EU countries, it will have to be borne in mind that you need to think about every country individually. So it's not just going to the EU, you will have to check beforehand what rules and provisions you have to comply with in the country that you or employees of your businesses want to go to. We will be dealing with some of these questions later on, and I'm now handing over to Craig.
Thank you very much, Sibylla. From a financial services perspective, the biggest thing to come out of the EU-UK trade deal was the conspicuous absence of financial services in the trade deal. For a document that comprised 1,400 pages, there are approximately 20 to 30 references to financial services within that document. That has created a lot of uncertainty within the financial services sector, particularly as on the 31st of December of this year, the mechanism by which financial services companies in the UK and the EEA could frictionlessly provide advice services across those borders has been removed. The passporting procedure has been removed. We're now left with a situation where companies who want to provide financial services to the EU have to go to each and every regulator for each and every country in the EU to seek approval. There is the possibility that that could be solved by what's called equivalence decisions, where the EU and the UK agree that the standards in relation to a particular part of financial services are equivalent, and therefore they can trade without friction, trade those services without friction. But there are issues caused by equivalence in that it is a temporary fix and can be removed at very short notice by either party. On the side of the person who's being supplied financial services, the current situation causes concern because there's a lack of detail around your own regulatory protections, such as how is your money protected, whether it's now protected by the Financial Services Compensation Scheme, by the FCA, if you're being provided by an EU provider or not. Do you need to go to the local regulator to find out how that's protected? And also there are questions about whether the contracts that you have already entered into with EU financial services providers continue to be operative and regulated. There is a financial services contract regime which allows those contracts to run off in the interim, but there are still questions to be asked about what happens once that period comes to an end. You should, as a receiver of financial services, check with your EU provider to see whether they are in the temporary permissions regime of the FCA, which may afford you some regulatory protections. I'll now hand over to Kunal, who's going to talk about restructuring and insolvency.
Thank you, Craig. From a restructuring and insolvency perspective, I think the biggest issue is that the EU regulation on insolvency proceedings is no longer applicable to new UK insolvency proceedings in the absence of any further arrangement with the EU, noting that there's nothing in the Trade and Cooperation Agreement on this issue. This basically means that there's no guarantee that the UK insolvency proceedings will be respected elsewhere in Europe in a consistent manner. Cross-border insolvency cases have always had an extra layer of complexity and difficulty for office holders, but unfortunately from the 1st of January of this year, unless an agreement can be reached with the EU on issues such as mutual recognition and enforcement of judgments, the job of achieving a rescue plan for a financially distressed multinational business, or indeed realizing assets in a cross-border case is going to become even more difficult and perhaps more expensive. And with that, I'll hand over to Joanne.
Thanks, Kunal. Certainly from my point of view, from a data protection point of view, the big issue, and which was causing quite a bit of concern in the run-up to Brexit, was the ability for personal data to continue to move both from the EEA to the UK and from the UK to the EEA. On the basis that the value of the data economy was valued at around 400 billion euros by the Commission in 2020, it was quite an important issue. And certainly from a practical point of view, it would affect businesses both from an internal point of view. So if you had a centralised HR function, for example, in the UK, but had group companies in, say, Germany, France, Belgium or wherever, then you still needed to make sure that the data could move around the company internally. And also from an external point of view, so obviously a lot of people these days have got service providers in the EU, they might have hosted data in the EU, so it was from that point of view as well. So essentially it did sort of form quite a key part of the Brexit negotiations in terms of what was going to happen, because without any sort of deal, the UK would be what's called a third country, and a third country is essentially any country outside the EEA, so essentially equivalent to, say, the US or Japan or any other country. And anyone certainly that has had the experience of trying to export personal data to the US will know that it's not always that straightforward, and there are certain additional hoops you've got to jump through in order to get the data into the US. So where we ended up was that the government made a statement quite early on that they would be happy, certainly in the short term, for data to continue to move from the UK to the EEA, although they have made a comment that that will be kept under review and so it could change. The big issue was whether or not the EU would do the same thing. And certainly where we got to in the Trade and Cooperation Agreement is that there has been an agreement for a 6-month bridging period. It's for an initial 4 months, but with an ability to extend for another 2 months. So there is a bridging period during which data can continue to move from the EEA to the UK. The point of the bridging period is that it gives the UK government and the Commission time to look into whether or not the Commission will give adequacy to the UK. And by adequacy, what I mean is that essentially an assessment is done of the UK legal system, the protection of personal data, to work out whether or not it offers equivalent protection in relation to the personal data. So essentially it's a 6 months breathing space has been included in the Trade and Cooperation Agreement, with the intention that adequacy will be dealt with during that period. Obviously, it's not a done deal on adequacy, so I think the big thing I would say for businesses at the moment is to watch this space in terms of whether or not adequacy will be given, because if adequacy isn't given, then it means that we've got a cliff edge potentially in 6 months' time again to make sure that personal data can continue to move from the EEA to the UK. So now I'm going to pass over to Georgie.
Thanks, Joanne. So in relation to IP, the changes in position about protection and enforcement after the 1st of January was dealt predominantly with the withdrawal agreement, and the transitions arrangements of various IP rates weren't actually changed as a consequence of the deal that was reached last month. The immediate changes really relate to EU registered trademarks and designs. I'm just going to give you a high-level view of what you need to be considering now as a rights owner. There are other changes. There isn't the time available to go through all of those today, but we do have a dedicated IP webinar next month, which will look at those in detail and how as a business you need to plan for them. So in relation to EU trademarks or designs, if you have a European trademark or European design, a comparable UK right will have been created on the 1st of January and you'll have a new registration number. The registration will retain the same filing and priority date and renewal date as the originating European right. The UK IPO has created over 2 million new rights at the start of this month. They've done a brilliant job and has said the transfer process has gone well. But in the course of checking our clients' trademarks and designs, we have seen errors with the records that have been created and the data showing. So what you should be doing is checking your comparable UK right has been created with the correct information. Specifically, it's got the same filing date as the EU registration and renewal date, and it's got your correct representative, i.e. attorney or lawyer details. Going forward, if you need dual protection in the UK and EU, you'll need to think about your budgets to allow for duplicate filing fees and renewal fees, along with the cost to get new marks and designs to registrations. For pending applications, it's estimated there's around 85,000 pending EU trademarks currently at the EU IPO. If you've got a pending EU trademark or design application, it is possible to file an application at the UK IPO for the same right during a 9-month window and to retain the priority date of the EU application. Our advice is actually to file any corresponding UK application now rather than waiting for that 9-month window. If you're thinking about launching, a new design, a new trademark and conducting clearance searches, You'll need to be mindful of taking into account that any application made at the UK IPO may fall in a 9-month window, relying on an earlier European trademark or European trademark. EU domains. Entities established in the UK and non-EU citizens residing in the UK will no longer be able to hold, register or renew a .eu domain with effect from the 1st of January. The relevant domains that are held by those entities are going to be suspended up until the 31st of March and won't be able to be used for emails or websites. You do have the opportunity to reinstate them before the 31st of March if you can meet the eligibility criteria, which is having a place of ownership of an EU entity in the EU. They are the principal immediate changes that you need to be thinking about.
Georgie, thank you very much. And just as a factual point, perhaps slightly ironic, one of the parties or organisations that wasn't properly prepared around that was leave.eu, which has had to re-register itself in Ireland in order to retain its right to be leave.eu rather than leave.uk or co.uk. Thank you very much for those comments over about key changes and differences. Before we go into specific questions, I would remind everyone on the call that when we're looking particularly at things like restructuring and insolvency and IP rights and also access rights for goods and services, and particularly financial services, our job as leaders of our businesses is to focus not just on our own entity, but also on our suppliers and their suppliers, and our clients and their clients, because our overall ecosystem is going to be significantly impacted in an unusual number of ways. And the better prepared we are around all of those things, the more likely we are to survive and thrive as entities ourselves in the current circumstances. An interesting illustration of that at the moment is again in Northern Ireland, where one of the supermarket chains is actually sourcing produce for Northern Ireland from a competitor chain in the Republic of Ireland, while other supermarket chains have got empty shelves. So one supermarket is facing up to selling product which is branded with another company's label, and other companies are not selling at all. Now that obviously has knock-on effects for their supply chain, their customers and so on, and this is why looking at the bigger picture is so important. I'm going to turn now to specific questions that we've had pre-submitted. I'm going to ask each of our partners in turn to briefly cover a couple of points on the pre-submitted questions, which, as I've said earlier, are summarised versions of a number of questions received. We've also started to get some questions coming through on the meeting chat, so please keep them coming through. If we don't have time to answer all of them, start with them in writing following the event. So I'm firstly going to turn to Sarah again, please. Sarah, in turning to tax, VAT and customs, could you please cover off what an exporter should know about rule of origin, or ROO, and could you also touch on invoicing clients in EU, whether we need to do it with VAT, and what VAT on imports, what the impact of that is, please, as a couple of points. So ROO and then VAT in both directions.
Yes, thank you very much, Bruce. So I think ROO, easy to remember from Winnie the Pooh, is going to be the most controversial area of the whole of Brexit as concerns tax. So as I mentioned earlier, to benefit from these preferential zero rate tariffs, the goods that you're exporting have to be of UK or EU origin. And they've got to meet the UK to EU preferential rules of origin. Now, there are detailed rules determining where goods are originating from, based on where products or materials used in their production come from. And this is where Marks and Spencer are running into problems with their Percy pigs, and that's just one illustration. So it will very much depend, obviously, on the facts of the individual case. So what is being used, what is being produced, the materials being used, and where they are from. Now, goods that do not meet the ROO can still be traded. So there's no bar on trading them. It's just that they're not going to be able to benefit from these preferential tariffs, and they may have to pay the standard tariff that the EU and the UK apply to import. So obviously this is going to push the price up on certain products. So any queries around that, please do come back to me after this session, because it will depend on the facts of your particular case. So for exports to the EU, this is going to be their common external tariff, and for imports to the UK, this will be the UK global tariff. And as I said, those tariffs, if you don't meet the RU rules, may be low or zero, but they could be much, much higher. And businesses might need to actually take a commercial decision whether it's in their interest to meet the RU in order to benefit from those zero tariffs, or whether they can negotiate with their suppliers. And as I said, there are detailed rules around that, so watch this space. Bruce mentioned a question we've had in from Peter G at Leisure Dreams, who I will just say hello to if he's on this call, because I do actually know him. So thank you very much, Peter, for that question. VAT on invoices for supplies of services. Nothing has really changed there. So from the 1st of January, the VAT rules applying for supplying services between the UK and EU member states are the same as the rules for supplying services from the UK to outside the EU. So if you're in the UK and your place of service is in an EU country, you do not need to pay UK VAT, so you don't need to add it to your invoice. But as I mentioned before, and it will depend on a case-by-case basis, for some supplies you may need to register and account for VAT in the country of your supply. And also, as a general UK VAT point, remember that if you're supplying services to somebody in the EU, your place of supply might not necessarily be in the EU, because it will depend very much on what you're supplying. For example, a very simple rule, if you're supplying legal services in relation to UK land, your place of supply is always in the UK and not where the client belongs. And that's an illustration of where it's very easy to go wrong. So I think they are the main two questions that we had in on place of supply and RU. And in relation to imports and exports generally, we have to deal with the usual rules on imports and exports that have been in place since before Brexit. Nothing much has changed there, but it's the rules on the concepts on removing goods to the EU have obviously changed in the terms of the EU is now a third country, and all sales of goods from the UK to the EU are now classed as exports. The rules of distance selling and VAT triangulation now cease to apply to UK business, and therefore the admin and the cost burden is going up and up and up. And as I mentioned in my introductory comments, it's very much now down to businesses to make sure that they've considered how they're going to clear and pay the import VAT and duty on the goods, both entering the UK and going from the UK to the EU member states. And I know that we've had one specific question around Italian VAT and whether you need to register for Italian VAT if you're exporting goods to Italy. Unfortunately, it's going to be a case of checking with the Italian VAT authorities on that as to whether you actually need to register for VAT in Italy. But please do, I'd be delighted to make contact with you after this webinar and discuss that point further, and how we can help you ease your compliance burden on that. So Bruce, I think those were the questions that you wanted me to deal with, and I'll.
Thank you very much. Thank you, Sarah, and we'll come back to Sarah a bit later on some specific questions about Northern Ireland. So I want to turn now to employment and immigration and to Sibylla. And I'm going to, Sibylla, add a question we've had submitted during the course of the call to the one that was pre-submitted. Please to answer both. And as a reminder, please, everyone on the call, please do feel free to submit questions and we'll try to get through them or in the call, or we'll follow up on them afterwards if we run out of time today. So Sibylla, the question that we've had is, what is the relevance now of the EU settlement scheme? And then is it possible still to apply for settled status? And the incremental question we've had is about whether it's still possible to sponsor settled or pre-settled subcontractors. So could I ask you please to address those for our audience?
Thank you very much, Bruce. To start with the EU settlement scheme, for EU nationals that arrived in the UK before 11 p.m. on the 31st of December 2020, it is still possible to apply for settled status, and the deadline for the application is the 30th of June 2021. If, as a business, you have employees who are EU nationals, we would recommend that you provide them with information about the possibility to register for settled status by the end of June this year. You should not be asking them to tell you at this point whether they have settled status, because until the end of June this year, the government has said that for EU nationals, it is sufficient to prove their right to work in the UK by simply showing their EU passport. As a business, that might put you into a difficult situation, because if you have, say, a new employee from the EU starting to work for you prior to the 30th of June this year, if they only show you the passport, you don't know whether they arrived before the end of last year or whether they only arrived from 1st of January this year. And if it is the latter, strictly speaking, they would be in this country illegally. That's a bit of a conundrum, and as I said, the government guidance doesn't help there because it is not clear. Apparently, more hopefully clearer guidance will be issued, and of course we will let you know and put that into our Brexit hub. The questions about sponsor license or licensing subcontractor who has settled or pre-settled status, if there is a subcontractor who has settled or pre-settled status as an EU national, that person is allowed to work in the UK, to continue working in the UK, and there is no requirement of anything else, assuming, as I said, that they have settled or pre-settled status. Otherwise, when it comes to subcontractors, so if we're talking about people who are self-employed, visas via the skilled workers route or other visas that require a sponsorship license on the part of the business would not apply to self-employed people. Self-employed people have to get visas in their own right, so they have to get the visas themselves, and there are some very strict and very stringent rules and very, very high hurdles for self-employed people to jump in order to get a visa in the UK.
Sabila, thank you. Hurdles everywhere. So moving on to Craig, please. And Craig, you touched earlier on a substantial level of change in terms of absence of certainty with passporting and other aspects, and the fact we've got to watch the space over the next few weeks as to what happens going forwards. We had a couple of specific questions tied to issues that are very relevant to most businesses. The one I'd like to raise initially, please, with you is what changes occurred to the UK money laundering regime on the 31st of December, and particularly also looking at impact on FS financial services providers and on those seeking financial assistance services in Europe from European entities. So could you please pick up on those?
Thanks, Bruce. The short answer is very little changed in relation to the UK money laundering regime, because the UK had adopted and incorporated into national legislation the 5th money laundering directive some time ago, and the 6th money laundering directive from the EU. We had already got provisions in place from a national perspective that went beyond the 6th money laundering regime. The one real practical implication of the leaving of the EU and the UK trade deal is that, as others have talked about, the UK is now considered a third country for EU purposes, and the EU countries are now considered a third country for UK purposes. And from a UK money laundering perspective, what that means is that financial services providers who are regulated from a money laundering perspective and who need to undertake customary due diligence are now required, if they're dealing with an EU entity, so company or an EU individual, to treat that individual as though they have to undertake enhanced due diligence. The practical implication being that they'll have to ask for more information about the individual or entity before the services can start. May mean that the provision of services is delayed, or what they're asking for causes more difficulties at the individual or entity end. On the other side of the fence, those who are seeking to access services in the EU are likely to be asked to provide more information from a customer due diligence perspective to satisfy that enhanced due diligence. And I think the message to businesses is just be aware of that, because if you are seeking to access financial services in the EU, make sure you build that into your time frame and contract time frame, so that you're not left stuck with the due diligence having to go through to be able to finalise the access. I noticed a question on the question and answer with regards to financial services in the UK. Are the UK more disadvantaged than individual EU countries? The short answer is yes. We're now going to have to, as it currently stands, if you want to access financial services or provide them in the EU, go to each and every individual regulator and seek permission to do so. It is very clear that the EU wants to centralise in the EU the provision of its financial services away from the traditional London market. And in the 2 weeks that we've seen since the UK trade deal, we've seen huge liquidity shifts from London to major EU financial centres, and that is indicative of what the EU was seeking to achieve. It's also of note that the UK has granted equivalence to a number of EU countries on a number of issues. The same has not happened in reverse. So the EU is playing hardball on financial.
Craig, thank you very much. Yes, as I said at the outset, the key thing to remember is this is something which has been done intentionally by our government with full knowledge, because they think they can achieve better or different outcomes, certainly from a point of view of meeting the political needs of the electorate, which may not necessarily align with the economic desires of all of us as businesses. The next questions, and thank you very much, we've now got questions flowing in, particularly around employment rights and VAT. We will pick those up if we can at the end of the conversation, or follow up, because some of them are really quite detailed with you individually and also on more general points collectively after the session. Kunal, could I now please turn to you? And you painted the picture earlier on about the impact of the change on insolvency proceedings generally. We've been asked a specific question about what options are available to business and insolvency professionals in dealing with cross-border restructurings and insolvency. So one of these things has been thrust upon you as maybe a customer or a supplier to an organisation. What are the options available, please?
Thanks, Bruce. I think it's helpful to explain the position prior to the 1st of January 2021. The starting point was the EU regulation on insolvency proceedings, known as the recast European Insolvency Regulation, provided a single set of rules for determining which court has jurisdiction over a dispute and provides for reciprocal recognition and enforcement of judgments between member states. As I mentioned earlier, of course, the recast European Insolvency Regulation is now no longer applicable to new insolvency, UK insolvency proceedings. And instead, the outcome for recognition of proceedings depends on the quirks of private international law in each EU member state. This, of course, increases the risk of competing insolvency proceedings between the UK and the EU due to the removal of the rule requiring automatic recognition of insolvency proceedings, and it also creates increased uncertainty for English insolvency practitioners seeking the assistance, of course, in the EU. Given the point of our uncertainty of mutual recognition and enforcement of judgments, I think there are a few options which practitioners who are advising financially distressed businesses could seek to rely on. We have the model law on cross-border insolvency, which seeks to provide cooperation between the courts of the home states and foreign courts in states involved in cross-border insolvency, and aims to reinforce the idea that foreign creditors have the same rights as local creditors. Recognition under the model law is not automatic, however, and will require an application to the foreign court. It's also important to note that the scope of powers under the model law is also limited and only allows procedural relief, such as stay of execution on assets belonging to a debtor. The only problem, of course, is that only a few EU member states have actually implemented the model law into their domestic legislation, those being Greece, Poland, Romania and Slovenia. And in circumstances where a member state has not implemented the model law, an office holder may have to obtain recognition of their domestic appointment in the member state under its local laws. There's also some international conventions that may help, which you mentioned earlier, Bruce. We've got the 2005 Hague Convention on Choice of Court Agreement, whereby states that are signatories undertake to recognise contractual exclusive jurisdiction clauses and are required to enforce judgments issued by the court selected by the parties. We've also got, as you mentioned, the UK signing up to the 2007 Lugano Convention, which governs jurisdiction and recognition and enforcement of judgments between the EU, Norway, Iceland and Switzerland. The convention reflects early iterations of the recast insolvency regulation, so it would be a better solution than the Hague Convention. Unfortunately, however, as you said, the UK's accession has been is subject to approval by the EU, which has not yet been provided for, and it may be simply a bargaining chip in wider Brexit negotiations. So we'll have to see where that gets to.
Great, thank you very much. And in the last 10 minutes, I'm going to ask Joanne briefly to pick up on a couple of DP points and a consumer law point, and then go on to finally some questions with Georgie on IP before we bring to a close in the last couple of minutes. Thank you all for the questions that are coming in. We will make sure that we answer all of them. So, Joanne, I'd like to ask you to briefly cover 2 points, please. The first one, which I think you started to touch on in your summary earlier, is around the fact that the transition arrangements are only in place for 6 months with no guarantee beyond that. So the question really, which has come up both pre-submitted and today, is around what businesses should do in the coming 6 months to prepare, and in particular looking at what they might do, as you touched on earlier, with contracts and with global clients. And then secondly, could I ask you briefly to go on and explain what the situation is with consumer law, given that most of that derives over the last 40 years from European legislation, EU legislation?
Yes, I think the questions are very interesting in relation to certainly the 6 month point, because whilst we have got, I think the best thing to call it is breathing space for 6 months, there is some uncertainty as to what will happen at the end of the 6 months and whether or not adequacy will be given. I can entirely understand why businesses are wanting to know whether or not they should do anything. Should they change their contracts? What can they do? I mean, one option is potentially to provide in your contracts that if adequacy is given, then that will relate to the export of personal data, and if it's not given, then have these standard contractual clauses pre-prepared and pre-signed. And certainly the ICO on that, they've not sort of made much comment at the moment in relation to the trade and cooperation deal, but one of the points they have made is that whilst it is to be welcomed, it's probably worth businesses looking to put in place standard contractual clauses in the 6 month breathing space. Now, I'm not sure that I entirely agree with that, because while standard contractual clauses are standard, there is some stuff that still has to be done in terms of filling in the detail of the export. There has to be some level of engagement with the business that you're trying to put them in place with. So it's not just sign on the dotted line, print them off, sign on the dotted line and don't worry about it. So it will involve management time, potential legal time. What I would probably say the more pragmatic approach, unless you're happy potentially to spend that time on the basis it might be unnecessary, is to maybe watch and see what's happening with the adequacy discussions. And if in 3 months' time it looks like we're getting nowhere with them, then start to look at putting in place the standard contractual clauses. One thing I will say however, is that standard contractual clauses, the ICO have ignored the point that they may not actually work that well with the UK, because for anybody, and I'm not going to go into it now, but there was a Schrems 2 decision in the summer last year, and that meant that you can't just sign the standard contractual clauses, stick them in a drawer and don't look at them anymore. There is some due diligence that has to be done around the legal system of the country to where the personal data is being imported. So I think if you wanted a bit of a belt and braces approach and you were happy to invest the time, as I say, you could amend your contracts now. My pragmatic approach would probably be to wait and see what is happening. I certainly think the government thinks that we will get adequacy. I think just to sort of throw something else in there, and I don't want to sound like the voice of doom, but privacy campaigners have also said that because primarily of our surveillance laws and the ability of the security services to carry out surveillance, they will mount a Schrems-like challenge to any adequacy decision that's made. So that is something that businesses also do need to sort of have in the back of their mind, that even at the end of 6 months, if we end up with adequacy, it is possible it will be challenged in the courts. So I think from that point of view, as I say, I would probably wait and see. From the consumer point of view, I think the point that the person who raised the question made is that a lot of consumer law within the UK is derived from EU legislation, and that's quite right. Certainly when Brexit happened, a lot of EU legislation was preserved, but in the consumer space, a lot of it didn't necessarily need to be preserved because we'd already transposed much of the consumer legislation into law in the UK. So things relating to the Consumer Rights Act, that derives from some movement that was being made in Europe in relation to consumer protection. Also things like the distance selling rules, that derive from Europe, but that's already in English law and law in the UK. So I think there's not a huge amount that is going to change from the legislation because a lot of it's been already implemented. The one point I would make in relation to anyone that's trading online from an e-commerce point of view, there was a very helpful provision in the e-commerce directive, which basically provided that if you are in the EU and you comply with the laws of your home state, then you can trade in other EU countries without having to comply with their e-commerce rules. That's now gone. So if you are trading online, unfortunately, you're going to have to do an exercise of going through the laws of all of the different states if you're trading in Europe to find out what their laws are and make sure that you are complying with it. So obviously that makes life a bit more difficult and certainly will add to expense in terms of taking legal advice. But on the whole, from a consumer point of view, I don't think there's a huge amount that's going to change simply because we've already implemented most of it. Obviously there'll be diversion going forward if we choose not to follow what the EU does, but at the moment I think there won't be a huge amount of change.
Joanne, thank you. No change. What a nice thing in the overall scheme of things. The critical two critical points also to reflect on with that, which just join up some of the topics we've had generally, are that online platforms also obviously attract tax and other things, and it's noteworthy that quite a few businesses have suspended their sales into the UK or into Northern Ireland, including some major retailers in the last 48 hours because of these complications. So do always look at the rounded picture of how the different types of law interconnect. Thank you all very much to our speakers. We're just coming to a close now. So I wanted to just very quickly do a few bit of housekeeping points. As I mentioned at the start of the call, we have provided the Brexit Hub, and the Brexit Hub is our way of keeping you up to date and helping you to raise questions with us as well. All of the partners on the call, and also, as I mentioned at the start of our call, our Avro partner, Caldwell and Robinson in Ireland, are happy to deal with quick questions you've got, and also to give you a 15-minute free consultation if you are not another law firm. There are further events in this series which are mentioned on the hub. The next one on the 10th of March is about Brexit and the impact of movement on people. And in a packed agenda before March, we also have a variety of other seminar sessions coming up over the next couple of months, which we can circulate out to you. I'd also encourage you please to look at the questionnaire and the feedback form that we've got, and give us some guidance about what you'd like to hear from us. not just specific questions, but also other events or topics you'd like covered in more detail, so that we can follow through with the workshops and the notes such as on supply of services, on data protection, on financial services, and how they involve and affect you going forwards. The final quick question and request, please, is please do give us the feedback on other things we can do for you, and most importantly, whether we can provide extra types of service or input for you. For example, potentially issuing you with a fortnightly Brexit or bulletin of brief updates on key points available. As we're now up to time, I'd like to thank all of our speakers. Thank you very much for attending and listening in today, and for your questions, which we'll follow up on going forwards, and remind you that this recording will be available after the event through the Brexit Hub, both for you to rewatch and also to share with colleagues as appropriate. Thank you very much, and goodbye.